Environmental law, protecting the environment. So the Environmental Protection Agency, also known as the EPA, is the primary agency that regulates environmental law. Other agencies that can also regulate specific areas of environmental law are the Department of Interior, Department of Defense, Department of Labor, Food and Drug Administration, and the Nuclear Regulatory Commission. Environmental impact statements, or the EIS, is a formal analysis required for any major federal action that will significantly affect the quality of the environment to determine the action's impact and explore alternatives. An EIS must all analyze the following: one, the impact that the action will have on the environment; two, any adverse effects on the environment and alternative actions that might be taken; three, irreversible effects that action might generate. So the common law recognizes that individuals have the right not to have their environment contaminated by others. Individuals suffering from harm or pollution rely on common law to obtain damages and injunctions against business polluters. There are two common law theories that hold people liable: common law theories of nuisance, common law theories of negligence. Common law theories of nuisance. So it is a common law doctrine in which people may be held liable for using their property in the manner that unreasonably interferes with others' rights to use or enjoy their own property. The courts will tend to balance the harm caused by pollution against the cost of shipping it. So that basically points out courts often deny injunctive relief because the hardships that would be imposed on the polluter and on the community are relatively greater than the hardships suffered by the plaintiff. To obtain relief from pollution, a property owner may have to identify a distinct harm separate from that affecting the general public. So an example of that would be Walmart has a factory on the outskirts of town and is a huge core for the local economy. Due to this factory, landowners are now suffering from smoke, soot, and other air pollutions. Since the factory is the core for the local economy, the courts will most likely leave the factory in operation and award monetary damages to the injured parties. So, common law of negligence and strict liability. So a negligence action is based on a business's alleged failure to use reasonable care toward a party whose injury was foreseeable and was caused by the lack of reasonable care. In a strict liability action, an injured party does not need to prove that the business failed to exercise reasonable care, which is also saying businesses that engage in ultra-hazardous activities are strictly liable for any injuries the activity causes. This could be a business who is driving radioactive materials. An injured party may sue a business polluter under the negligence and strict liability theory. So what is pollution? Pollution is the presence in an introduction into the environment of a substance or thing that was harmful or poisonous effect. Two types of pollution are air pollution and water pollution. Air pollution, which is also known as the Clean Air Act. The Clean Air Act provides the basis of ensuing regulations to control multi-state air pollutions. So that part, it covers both mobile sources of pollution, such as automobiles and other vehicles, and stationary sources of pollution, such as electric utilities and industrial plants. Clean Air Act puts standard on the manufacturing plants. The Clean Water Act makes water safe for swimming, protects fish and wildlife, and eliminates the discharge of pollutants into the water. The standards the EPA sets on the discharge of pollutants into the water strictly enforce penalties, include our fines and even imprisonment. In order to discharge pollutants into the water, you must have a permit. So example, Dr. Jones owns 1,000 chickens and has been selling the eggs out of his house over the past year. Dr. Jones also lives on a lake where he has been dumping the animal waste in the water. On one particular day, while he was dumping the waste, Dr. Jones was spotted by a DNR sheriff. Will Dr. Jones be in trouble with the law? Why or why not? And what is he missing? Toxic chemicals and hazardous waste. Toxic chemicals and hazardous waste is a potentially dangerous byproduct of a wide range of activities. So, the federal insecticide, fungicide, and rodenticide, also known as the FIFRA, regulates the use of pesticides and herbicides. These substances must be 1. Registered before they can be sold, 2. Certified and used only for approved applications, and 3. Used in limited quantities while applied to food crops. Common examples of potential dangerous activities could be many, which is 1. Manufacturing, farming, water treatment systems, constructions, laboratories, hospitals, etc. The Toxic Substance Control Act regulates chemicals and chemical compounds that are known to be toxic, such as PCBs. The Act controls the introduction of new chemical compounds by requiring investigation into any possible harmful effects from these substances. The Resource Conservation and Recovery Act, also known as RCRA, was passed in reaction to concern over the effects and hazardous waste materials on the environment. The RCRA requires EPA to determine which forms of solid waste should be considered hazardous and control the waste disposal of it. Any questions after that?